3 minutes past the hour. Dr. Wilmer Leon here. Inside the Issues is where you are. And I hope you all enjoyed that conversation with Dr. Willie Jolly, Jolley, and his wife, D. Taylor Jolly. Make love, make money, make it last. 10 secrets to shape a great marriage. Go to Jolley, Jolley, marriage.com, jollymarriage.com. And that right there, someone stole my chitlins. That's from Les McCann Limited. That's a New York live release, 1962 Pacific Jazz release there. That's Blue Mitchell on trumpet. Anyway, the citizens of USCC number 16-1464 are tired of being told by established authorities that unlike Ukraine, Austria, and Kenya, the U.S. is not able to save itself from a stolen election by having a new one. They have filed a petition for writ of mandamus to the U.S. Supreme Court docket number 16-1464, or Bailey et al. V. United States et al. It is the only legal action seeking an independent investigation into the 2016 election, and if collusion is found to have occurred between the GOP campaign and Russia, the election should be declared void ab initio, or from the beginning. The case is set for conference on September 25th. According to my guests, this effort is not partisan for either party. They believe the effort is to take control of the Oval Office back from a hostile foreign power, which is Russia. To gain more insight into this case, we turn to my next guests. First, spokesperson for Revote 2017, Kirstin Martin. Greetings, welcome, good afternoon, and thanks for going inside the issues.
Well, Dr. Land, thank you. I'm so astonished because you just explained so succinctly what we're doing, so there's not really much more that I can say except to thank you for getting the word out. It's just, I think a lot of people probably shared our just shock, the election night and the day after. But, for whatever reason, even all the pollsters who unanimously had predicted the election would go the other way started trying to explain why they were all wrong, instead of just kind of what I think was looking in the eye at just so much evidence that had been there throughout the election right after. And so for me, I'm just like Dorothy and the Wizard of Oz. And my mother does live in Kansas, but I just woke up. Thank you. It's true. You wake up, there's a tornado. It's not the world you chose to be in, but there's a clear path. There's just one path. It's investigation, nullification, new election. And along the way, you are blessed to be joined by people who aren't the usual suspects necessarily, but who end up being the real heroes. And I'd like to just leave it at that, because we're very blessed that after all the brand name constitutional lawyers told us all the reasons why our Constitution would not function properly for us, Mark Small stepped onto the scene, and he hasn't looked back, and he's very well versed in the Constitution, and I'll let him take it from there. But we're just very we're blessed to be joined by an attorney who's admitted to practice at the Supreme Court, who can take our ideas of being citizens and put them into proper legal language. To Kirstin Martin's point, we are also joined by the attorney for Revote 2017, who has filed this case on behalf of Revote 2017, Mark Small. Greetings, welcome, Mark, and thanks for going inside the issues.
Dr. Leon.
How are you?
I just clarify, it wasn't filed on behalf of Revote 2017. Revote 2017 has been great and advocating this, but there are 12 individual petitioners.
Got you.
So that's an important distinction.
No, well, go ahead and explain why.
Because Revote 2017 is an organization that can't really bring the action, but these individuals, 10 individual petitioners, can bring an action. They were wronged as citizens. They cast their vote in an election in which their election votes were nullified. The only people who had their right to vote actualized in the election were any people who voted intending to vote for a puppet of Vladimir Putin for president of the United States. Otherwise, everybody, even those people who voted for Trump and third-party candidates, as well as people who voted for Secretary Clinton, had their right to vote taken away.
Kirstin, if you could briefly explain Revote 2017 and what is it that your organization is trying to accomplish?
Yes, so thank you. We are the ones who started getting like-minded people together, getting our information correct, and finding the solution. And then what we do now is we have been rallying around and encouraging and promoting the 12 brave petitioners. And, you know, our legal case, we're asking people to speak out on behalf of the United States. We're getting publicity. We're raising funds. We're doing all of the things except the actual legal case itself. And so we are just a group. Our goal right now, Dr. Landon, again, I appreciate so much this forum. You're such an important person now more than ever. There's so few organizations and people who just take time discussing issues so deeply. But our goal right now is just to get everyone's attention to the fact that on September 25th, the only thing we need to ask our Supreme Court to do is to agree to hear the case. So they're not going to decide whether or not the election was stolen. They're not going to decide anything about a new election. They're simply going to consider whether or not to hear our case. So even those who don't think this legal case has a chance should be in favor of the Supreme Court telling us, if that in fact is true, why that's the case. In other words, we need to hear from the Supreme Court on this issue. So our goal is to be a mouthpiece and to really get as many people awake and aware of their rights as citizens and their right to hear from the Supreme Court on this issue.
Mark, if you could, as simply as possible, this is not a simple issue. The United States is a constitutional republic, and we have a federal system of government, which means the power that is not reserved for itself by the national government is then left to the states. So if you could explain what is the legal rationale for Bailey et al. V. United States et al.
Sure.
Well, first of all, does that question make sense?
Yes, it does.
Okay, all right.
And I had a bunch of lawyers try to rip into me that saying that there's no basis. There are only two ways to remove a sitting president specified in the Constitution. One is impeachment. The other was was ratified in the 25th Amendment in 1967, and that's removal if the president cannot perform the duties of office.
Mm-hmm.
What nobody paid attention to was in 1976, a U.S. District Court in New York, in ruling on an election question, said, well, there's no doubt, and Donovan versus Board of Elections, there's no doubt that federal courts can declare void an election if it were obtained through illegal means. It's difficult to consider anything that would be a greater blow to our concept of democracy than if the margin of victory for the election of president of the United States was provided by illegal means. So it lies within the equitable jurisdiction of the federal courts to take such action if it's necessary. So it's the equitable jurisdiction. And in Marbury versus Madison, one of the early cases in our republic, John Marshall wrote that where there is an injustice and no remedy specifically exists in the Constitution, the court will provide it. And Alexander Hamilton wrote that those powers that are implied for the government that aren't specified, you don't have to go through them and itemize them. They're available there. And so nobody would, and the Constitution itself, the original document, isn't that long. So there were things that were understood that could arise as problems. There's no specific provision for nullifying an election written out in the Constitution. It says it can be nullified if this happens. But it's certainly been done in our history. We've had elections nullified, and so the court can do it.
But isn't one of the reasons why there's no remedy to nullify an election written into our Constitution is because, as Professor Lonnie Guinier wrote in Demos Prudence Through Dissent, the federal government defers to 50 states and 13,000 locally administered jurisdictions the barely regulated responsibility to enforce the right to vote. It's not the federal government that has assumed that power. The or the national government has left it to the states.
Generally, but ultimately, the federal government is the final authority, and it that is in the Constitution. And if you look at the cases, Baker versus Carr, any other voting cases, ultimately, when there's a dispute with the states and the states have tried to do something to subvert the right to vote or to circumvent people's rights in that way, it's the federal government that does have the authority. Yeah,
you're right. It is the federal government, but from most of what I've read, it is the federal government, and I'm saying this to my audience, not to you, because I know you know this. The federal government consists of three branches. It consists of the legislative, the executive, and the judiciary. And so Congress has, so the federal government element whose job it is to do this is Congress, not the Supreme Court.
No.
No? Okay.
Congress can legislate certain things, but the ultimate protector of our rights is the Supreme Court, is the judicial branch. Madison wrote in Federalist Paper number 43, whenever there's a dispute such as this, it's the judicial branch that would be the natural arbiter. But also, ultimately, when it comes to people's rights, if it had to do with segregation, for example, the Supreme Court handed down Brown 1 in 54. If we had to wait on Congress and the Dixiecrats, it would have been a long time before even those steps were taken. So there are
but the Supreme Court in Brown 1 and 2 did not make law. What they did was ruled on the constitutionality of existing law. Brown didn't make new law. Brown, they ruled that separate but equal was as it stood as the law of the land was unconstitutional.
I know. That's right.
Okay.
And this is a question of first impression for the Supreme Court.
Okay. Now, okay, that's what I wanted you to get to. So explain what that means. No, let's do this. I'm sorry. Let's do this. Let's take a break, and then I'd like for you to explain that, because that's the point I was trying to drill down to. Sure. It's 16 past the hour. Dr. Wilmer Leon here. Inside the Issues is where you are. And Kirstin, is it revote2017.org?
.net. And thank you for asking, because we have had outside parties that like to try to distract. Everybody's distracting everyone. It's revote2017.net. Thank you for asking. Yeah,
go to revote2017.net. This is a very interesting case, and this is a very interesting issue. Go to revote2017.net. The citizens of USSC number 16-1464, which is a writ of mandamus to the U.S. Supreme Court docket number 16-1464, or Bailey et al. V. United States. They are asking the Supreme Court to rule on whether or not there should be a independent review of the 2016 presidential election. More on the other side. We're coming up on 17 past the hour. Attorney Mark Small and activist Kirstin Martin are my guests. And right now, listen to this. Someone stole my chitlins, as in someone stole my vote. Les McCann Limited. It's a 1962 live recording on the Pacific Jazz label. Keep it locked right here. Sirius XM 126 Urban View.